I have a case scheduled today that was filed by Brian Azell, Ezell, versus Christian, Kristian Ross. It involves minor children between the parties. Mr. Ezell lives in Butler County. Ms. Ross has returned to Nevada, as far as I can tell. There is a pending criminal case in which Mr. Ezell has been charged with battering Ms. Ross in Butler County. It is scheduled in front of Judge Webster, I believe, on August 24th. And Mr. Ezell has signed a bond with AAA that orders no contact with Ms. Ross or the minor children. He has retained an attorney, or an attorney has entered. I don't know if it looks like he's retained, but it is Eric Kidwell, who filed on July 21 of 2026 a motion to modify conditions of bond to allow him to have contact with his children. There is one child that is of the age of majority, and there is one child, as I understood it, that is in Butler County that is maybe in high school. And I'm not sure who she's living with, but what I have discovered overall is that in looking at your documents and your UCCJEA, which it appears that you both filed, and Ms. Ross, you filed an answer in this matter, is that the divorce between the two of you occurred in Clark County, Nevada, and that court took jurisdiction of, at that time, all four of the children. And so that court continues to have jurisdiction over the children until there's been a change of venue or a basis pled to the court for the court to confer with Nevada to change venue. And frankly, Ms. Ross, since you're back in Nevada, in all likelihood, it will take a motion in Nevada to modify custody, parenting time, or to change venue if you'd rather litigate the matter in Kansas, as long as the Las Vegas district court approves. So Mr. Azell, even though a parent can file a PFA, a protection from abuse, if their child is in immediate danger, on behalf of the children, where a court can take emergency jurisdiction to protect a child, just like a child in need of care case, the court can't just take over jurisdiction of children when they have a court of jurisdiction in another state, even in another county to some degree, but definitely in another state. So you needed to go back to Nevada court and ask for a transfer of venue to Kansas, or modify and get custody orders out of Las Vegas. So I don't believe that I have jurisdiction today to award anything to anyone. Now, Mr. Ezell, is Mr. Kidwell going to enter an appearance in this domestic case? Have you retained him for that matter?
Yes, Your Honor.
Okay, He has not done that to this point that I'm aware of. And Ms. Ross, are you
Yes,
living back in Clark County?
I am. I'm currently living here. I'm established. I have a job. My younger two are enrolled in school. I did have a question for you. If
Well,
I wanted,
let me ask you a few more questions.
okay,
So at the time of this divorce in I don't know if it's 2020, yeah. In February of 2020, so just prior to COVID, Mr. Ezell was living or working in Colorado, correct?
yes,
Okay. And you stayed in Vegas.
yes.
And then at some point he moved to Kansas.
He moved to Nevada first, then to Kansas.
So he moved back to Nevada
Yes,
and then to Kansas.
yes.
And how long were you in Kansas?
4.5 years.
Okay. And so the kids were enrolled in school here and everything else.
Yes.
All right. Well, you may not have the home state advantage since you moved. If two people have children, they get divorced, one person moves and the other party never moves, that jurisdiction always remains until order of that court in the state in which it was filed and where that one parent remained. When that one parent leaves and goes to another state, then there can be jurisdiction in potentially in both states. Now, my concern is though that you have returned to Las Vegas. And even if we both have jurisdiction of the children potentially, since they were the initial jurisdiction where the initial commencement of an action involving custody of the children occurred, they would have to agree to confer jurisdiction here. And then there would be an assessment of things like convenience, what's the proper forum, all of that kind of thing. So that is a subject of potential jurisdictional litigation down the road, unless you concede to Kansas having jurisdiction and I contact the court there and they're willing to relinquish jurisdiction. However, I think they're going to be a little reluctant to agree to that, given the fact that the kids are now back in physically located in their jurisdiction. So I'm not sure where we're going to end up with all of this, but the first thing that has to be addressed is appropriate jurisdiction. And you cannot confer jurisdiction on the court. The court either has to have original jurisdiction or the court by rule of law has obtained jurisdiction. And I don't think I have, under the UCCJEA, have today clear jurisdiction. I'm not even sure I did when this petition was filed in 26 DM 309 back in, sorry, trying to find the date here. It looks like it might have been, Amy, can you look on the ROA and tell me when the petition, when this stuff was originally filed? July 22nd?
That's correct, Judge. It was all, no, the petition to establish parentage was filed by Mr. Ezell on July 20th.
Okay, 2 days before. Okay. This is not an appropriate matter of determination of parentage. You two were married, you got divorced. your parentage was established a long time ago. And it was definitely established at the time of your divorce in 2020, like I said, when the court got jurisdiction. Mr. Ezell, you might have had a stronger case if you had filed for a transfer of venue to Butler County while she was still physically here and the kids were here. If she had been here as long as she stated she has been, but that's not the current circumstance. And I don't believe that was.
I didn't know that she had left. She just up and left out of the blue when I was in jail.
Yeah.
And then left.
She told the officers in this case that she was taking the kids back to Nevada. So that was before you filed this in July.
Correct.
All right, so I assume, Ms. Ross, you want to confer with an attorney in the courts there in Nevada. That you're just not, you did file an answer, and that confers some degree of jurisdiction to the court, but this is not a proper paternity filing by law. And I'm not suggesting it can't be consolidated or transferred to an out-of-state custody case here, but it's not a proper paternity. And you can't, by your answer, confer jurisdiction of the children. That's something that's done by the Uniform Custody and Jurisdiction Act that's been adopted by probably at least 48, if not all 50 of the states in the United States. So, let me ask you, the oldest child who is with Holly Harp.
The daughter, Leah.
Yes. Which is Leah's best friend, right?
She's with her best friend's mom.
Okay.
She's gonna stay for the summer and then asked me, can I live with my dad and go to school in Kansas?
Okay.
And before I even got to have a conversation with Mr. Ezell, I was served with papers seeking sole custody. And after his criminal date, I was going to work something out to where she could stay with him and go to school because that is what she would like to do.
Okay.
She would like to finish her high school career there. She's in sports, and I understand that.
Okay.
I would love
Is
to
she
have her
gonna
here
be
with
a
me.
sophomore?
Is she what?
Going to be a sophomore?
Mm-hmm.
And what school is that?
She goes to Augusta High School.
Okay.
But the younger two are going to remain in Nevada with me, and they're enrolled in schools already here.
All right. Well, what I would suggest, Mr. Ezell, I can't give legal advice here, but this has all gotten pretty convoluted, and there's a criminal case that you want to be careful that's pending. So, Mr. Ezell, what I would suggest you do is get a hold of Mr. Kidwell, have him enter appearance in this case before she moves for a dismissal, because she probably might be entitled to a total dismissal of this case based on the fact that it's not a paternity case. And the court may not have jurisdiction depending on the arguments made. But I would enter this case before it's dismissed. And if he can talk to Ms. Ross, because you can't talk to her, and get some kind of written agreement that you can file in the Las Vegas court. Now, it's going to have to be a Las Vegas attorney that does that. So at the same time, Ms. Ross, if you want to talk to an attorney, or you can fill out paperwork yourself like he did here to get an order that allows her to live with him in Kansas, and attend school until this next summer, you're free to do that. But you're gonna have to get an order out of that court until jurisdiction is transferred here. Or it's gonna stay there. I don't know
Can I
how,
ask a question?
yes.
Can we not just agree to let her live with him for the time being and I retain my custody? Am I not allowed to let her live with him
I'm not
and
gonna
just
give you.
keep it the way it is?
I'm not gonna give you legal advice on that. I would tell you if the case arose here, you should always have a custody order on file that reflects what the current situation of custody is. So.
So there's
I'm not-
no way of getting her home
I'm
today.
not gonna give you any legal advice about what you can do outside of court or anything else, or in Las Vegas or anywhere. I'm just telling you that I have an issue with making a custody order in a paternity case where there's existing divorce case from 2020 where there are existing custody orders. Even though some of the facts have changed, and especially in light of the fact that you've returned to Las Vegas with 2 of the children. So you can seek legal advice. You can talk to Mr. Kidwell. I would suggest you not violate a criminal court order that says you can't talk to each other. And that you go through an attorney until or unless those orders are modified in some way. And technically it looks like by way of the bond potentially that's supposed to get straightened out on August 24th. Or before then, if Mr. Kidwell can get with the judge in that case, some potential issues with him having contact with the children.
So he did file a motion. You saw that, and
Saw that, but he hasn't set it for hearing. I haven't seen where it's been set for hearing or modified.
yeah, I haven't heard anything back from him. He hasn't heard anything back from the judge either.
Well, usually you have to initiate hearings with the judge. You can file pleadings, but that doesn't get in front of the judge to schedule something unless you contact the judge's office to get it scheduled.
So there's nothing we can do to get my daughter back home at all today.
There's nothing I can order.
Okay.
No, I cannot. I'm sorry.
Even if we both agree on terms and everything like that, there's
Right,
nothing.
because that the court of current jurisdiction is Las Vegas. And I can't, without a transfer of custody here or an okay by the judge in Clark County, make any custody orders.
Okay. I had talked to a lawyer out in Las Vegas, and she had said because we've been residents of the state of Kansas for 6 months or more, that she said the case doesn't have to go through Nevada. Everything can go through Kansas. And
the kids aren't, when you file the case, you could make a claim that their home state is here and they've lived here 6 months and both of you have left, but she's back there now. So the circumstances have changed. That court still has jurisdiction and 2 of the kids are still physically there. And the other thing you don't want happening, Ms. Ross, is if the county attorney's office finds out that he has that daughter and they don't believe, based on his conduct in this domestic violence case and some of the issues, that it is an appropriate environment for her and
Right.
you're not there, they could file a child in need of care case and place her, you know, I would hope not, but they could place her in temporary foster care. And you wouldn't be able to get her back in Las Vegas until Interstate Compact became involved and allowed it.
So I need to bring her back here.
Well, I think that you need to both confer with the attorneys, and if you want to do an agreement, you file it in Las Vegas and you ask for a change of venue. I've never had a case where kids have been separated and there was a change of venue for one child, but not the other.
Okay.
Generally, the law does not prefer separation of children. It's not to say it hasn't happened and doesn't happen, but generally speaking, as a public policy matter, the law does not prefer courts to split up children. Okay, but I'm not saying that can't be done,
Mhm.
but there's got to be a court that decides what's in her best interests.
Okay.
And right now, that still appears to be the Las Vegas court. Unless there is a change of venue requested of me, and I confer with the judge there, and some decision's been made, which you know, may involve some concessions by you. So just talk to your respective attorneys, figure out what you can do on your own, decide what you think's best, make your decisions. But until I have authority in this case, or a change of jurisdiction for custody, if of at least one of the children, if not all, here, I cannot give any lawful orders that would allow the child to stay here or allow the child to return to Las Vegas. I'm sorry.
Yeah, I'm keeping jurisdiction on Emma and Owen here. The only reason I changed it with Leo is because she wanted to finish high school there.
I
And I
understand.
understand that.
And you can file something in your domestic case there that requests that here. And then you can file something here, you know, by way of changing the petition in this case, or filing a new case to transfer custody, and Las Vegas will contact us and can agree to that, and the court can accept jurisdiction of one child. I will have to look at UCCJEA a little further though on separate custody orders separating children from the same case.
Yeah, the other two weren't mentioned in this case, just her.
No, I know, but you just can't do all that. It's just
Right.
it's just not that simple between states. There are very specific rules about transfer and change of custody and venue and all of that.
So can we just agree on something between me and her, like you said, and then file it in Nevada, and then she can come home to me?
I'm not going to give you a legal advice.
Okay.
That is something that you can, I don't know how you're going to attempt to do that without since you can't communicate with her until you have Mr. Kidwell or some representative involved. And
So he
that's
can-
probably who you
What about
should
Mr.
talk
in
to
school? He can learn
about
about the other systems
facilitating
and
all
lots
of
of-
this. There is a way to facilitate it. I'm not even licensed to practice law in Nevada, so
Yeah.
you know, I'm not gonna tell you off the record what you can do. All I can tell you is what I can and can't do based on your filings here.
Okay.
And I will go ahead and set this case. I'm not dismissing the case today. I will place a stay on the case and set it over, excuse me, for you guys to figure it out.
Okay.
Okay? And I'm probably gonna do it after this August 24th court date.
For the meantime, is there a way I can grant Holly temporary guardianship so that Leah can start school? Or do I need to move her to Nevada until these things are solved?
I cannot give you legal advice. If you want to contact DCF or an attorney with DCF in Kansas, you can do that. If Holly's mother wants to go see a lawyer and see what she can file and do with both of you consenting to a voluntary guardianship. I mean, I'm just throwing things out there, but I cannot give you legal advice how to make this happen. I can only say based on what you filed, what I can and can't do. And what I know about any other cases that are filed. Okay, so I know about in this jurisdiction, the criminal case, where there are some no contact orders and there are some bond provisions. Now, I am questioning a little bit whether the bond reflects exactly what the court ordered. And I don't see where the bond has been signed by Judge Webster. No matter what's ordered, a judge can order things on bonds. But then when the judge gets the actual bond, if the judge approves the conditions that are listed on the bond, then those are your conditions. A bondsman can add some conditions to a bond sometimes, and the court approve it as well, like GPS or something of that nature. But I'm not real clear on, I know there's a bond on the two of you, and it looks like there is some bond issues with the kids. And obviously Mr. Kidwell has acknowledged that because he filed a motion to modify, and that needs to be heard. So
the original
that will not be heard until August 24th. And
so the original bond condition
actually,
was,
Judge Webster has signed this bond. I just got handed. She didn't sign on the bond itself that I'm looking at, but she did approve the appearance bond on a separate electronic signature page. So
the original bond when I was in jail, when I talked to Judge Hart, was no contact with Miss Ross, but I could talk with my kids, just not about the case or anything like that, or see my kids. And then when I was signing out of jail, they said it got
I'm not going to
modified.
modify any existing orders, and I'm not going to give you any advice. Your attorney has filed a motion to modify in that criminal case for the kids because he acknowledges that there is a bond condition that you not talk to them or have contact with them. And that has been signed by Judge Webster, who is your presiding judge in the case. And so that's who you need to go to resolve any questions about that. Okay?
Okay.
And it does need to be taken up with a judge. Not me, I'm not the assigned judge. Okay, so I want to review this case on Tuesday, the 25th by Zoom at 11 o'clock. Okay?
Yes.
I'm sorry I cannot help you any further. Again, I really encourage you to get with one or both of you, get with an attorney in Kansas, and one or the both of you get with an attorney, even if it's like a legal aid attorney or something in Las Vegas, and see what you can come up with. Okay?
Okay, thank you.
All right, if there's nothing further today, we are adjourned. If Mr. Kidwell contacts me, files something, and wants something heard in my case, I will hear it before the 25th.